I was sitting on my back porch with a beer in hand when I saw the construction crew roll up to the property line between my house and Sharon Whitmore's place. Sharon was the president of the Meadowbrook Hills Homeowners Association in Scottsdale, Arizona, and she'd been a thorn in my side since the day I moved in 3 years ago. The woman had filed complaints about my mailbox being 2 inches too far to the left, my trash cans being visible from the street for more than 12 hours, and my lawn being a 1/4 inch too long during monsoon season, when it was literally too wet to mow. My name is Stephen Barrett, and I'm a mechanical engineer who works from home most days. I bought this 4-bedroom ranch-style house as a fresh start after my divorce, thinking a quiet neighborhood in suburban Scottsdale would be perfect for rebuilding my life. What I didn't anticipate was living next to someone who treated the HOA rules like they were the 10 Commandments carved in stone. I watched as 3 workers in hard hats started unloading fence posts from a flatbed truck. That's when Sharon emerged from her house wearing her usual uniform of khaki capris, a white polo shirt with the HOA logo embroidered on it, and a sun visor that made her look like she was perpetually ready to complain to a golf course manager. Her blonde hair was pulled back in a tight ponytail that seemed to stretch her face into a permanent expression of disapproval. "Morning, Stephen," she called out with that fake sweetness she always used before dropping some new rule violation on me. "Just getting some landscaping improvements done. Hope the noise won't bother you too much." I stood up and walked toward the property line, beer still in hand. "What kind of improvements are we talking about?" "A privacy fence," she said, gesturing vaguely. "I'm entitled to one under HOA guidelines. 6 feet tall, neutral color, standard cedar construction." "Okay," I said slowly. "But you know where the property line is, right?" She laughed, but it had that edge to it that made my neck tense up. "Of course I do, Stephen. I had a survey done last month." That should have been my first warning sign, but I had a project deadline looming and honestly didn't have the energy to argue with Sharon that morning. I went back inside, put on my noise-canceling headphones, and tried to focus on the engineering specs I needed to review. Over the next 3 days, I heard hammering, drilling, and the whine of power saws. I glanced outside periodically and saw the fence going up, but I was buried in work and figured I'd take a proper look once they were done. My girlfriend Amanda Sullivan had been telling me I needed to pay more attention to what Sharon was doing, but I'd waved her off. "It's just a fence," I'd said. "What's the worst that could happen?" Amanda had given me that look, the one that said I was being naive, but she dropped it. She was an interior designer with her own firm in downtown Phoenix, and she understood work pressure. Still, she'd muttered something about Sharon being up to no good as she'd left for a client meeting. On the 4th day, I finally finished my project and decided to take a walk around my property to clear my head. That's when I saw it. The fence wasn't on Sharon's property line. It wasn't even close. The brand new cedar privacy fence, standing 6 feet tall and stretching across the entire width of her backyard, was a full 10 feet into my property. I stood there staring at it, my brain trying to process what I was seeing. 10 feet. That wasn't a mistake or a minor miscalculation. That was a deliberate land grab. The fence cut through what used to be my flower bed, encroached on my patio area, and basically stole a significant chunk of my backyard. I immediately walked over to Sharon's house and knocked on her door. She answered with that same fake smile, holding a glass of white wine even though it was only 2 in the afternoon. "Stephen, what can I do for you?" "Your fence is on my property," I said, trying to keep my voice level. "It's about 10 feet over the actual property line." She took a sip of her wine and shook her head. "I don't think so. I had a professional survey done, remember? The fence is exactly where it should be. Sharon, I have my property survey from when I bought the house. The fence is absolutely on my land. You need to move it." Her expression hardened. "I'm not moving anything, Stephen. The fence is on my property, and if you have a problem with it, you can take it up with the HOA board." "You are the HOA board president," I said, my frustration rising. "Then I guess you're out of luck," she said, and closed the door in my face. I stood there for a moment, shocked by her audacity. Then I pulled out my phone and called Amanda. "She did what?" Amanda's voice rose an octave when I explained the situation. "Built a fence 10 feet into my yard. And she's claiming it's on her property. Stephen, you need to get a lawyer like yesterday. This is insane." She was right. I went back inside and started searching for property attorneys in the Phoenix area. Within an hour, I had an appointment scheduled for the next morning with Robert Chen, a real estate attorney whose reviews specifically mentioned HOA disputes. That night, I couldn't sleep. I kept thinking about that fence, about Sharon's smug expression, about how much of my property she'd just stolen. I'd paid good money for this house, and every square foot mattered. Plus, it was the principle of the thing. You can't just build a fence on someone else's land and expect to get away with it. The next morning, I met with Robert Chen at his office in downtown Scottsdale. He was in his 40s, wearing a crisp navy suit, and he listened intently as I explained the situation. "Do you have your property survey?" he asked. I handed him the documents I'd received when I purchased the house. He studied them carefully, then pulled up a mapping program on his computer. "This is pretty clear-cut," he said. "The fence is definitely on your property. Do you have photos?" "Tons," I said, showing him the pictures I'd taken from every angle. He nodded. "Here's what we're going to do. First, I'm going to have an independent surveyor come out and document exactly where the fence is in relation to the property line. Then we're going to send Sharon Whitmore a formal demand letter requiring her to remove the fence within 30 days. If she refuses, we'll file a lawsuit for trespass and encroachment." "How long will this take?" I asked. "If it goes to court, probably 6 months to a year." But many times, once people realize they're actually going to face a judge, they back down. I hired him on the spot. The surveyor came out 2 days later, and his findings confirmed what I already knew. The fence was 10.3 feet onto my property at its closest point and 9.7 feet at its farthest. He marked everything with bright orange stakes and flags, documenting it all with photos and GPS coordinates. Robert sent the demand letter via certified mail. Sharon signed for it 3 days later. I waited anxiously for her response, checking my mailbox constantly. When it finally came, I couldn't believe what I was reading. According to Sharon's response letter, written by some cheap attorney she'd found, she was claiming adverse possession. Apparently, she believed that because she'd had de facto use of that strip of land for years, because I'd supposedly abandoned it by not maintaining it properly, she now had the right to it. It was complete nonsense, of course. You can't claim adverse possession of someone's property after only 3 years in Arizona. The minimum requirement is 10 years of continuous, open, and notorious possession. "She's grasping at straws," Robert said when I forwarded him the letter. "This actually works in our favor. It shows she knows the fence is on your property, but she's trying to justify it anyway. That's going to look terrible in front of a judge." We filed the lawsuit in Maricopa County Superior Court. Along with demanding the fence's removal, we added claims for property damages, loss of use and enjoyment of my land, attorney's fees, and court costs. Robert suggested we also seek punitive damages given Sharon's flagrant disregard for my property rights, and her position as HOA president. She used her authority as HOA president to intimidate you and make you think you had no recourse, Robert explained. That's an abuse of power. Judges don't like that. The discovery phase of the lawsuit was eye-opening. Through subpoenas and document requests, we uncovered some disturbing information. Sharon had indeed had a survey done before building the fence, but she'd done it herself using a cheap handheld GPS device, not hired a professional surveyor. She knew the approximate location of the property line and had deliberately chosen to build beyond it. Even more interesting were the internal HOA emails we obtained. Sharon had been corresponding with other board members about my property for months before the fence went up. In one email, she'd written, "Stephen Barrett is a problem resident who doesn't respect the community standards we've worked so hard to maintain. If we can't force him out through fines, maybe we can make his property less appealing." Another board member, Patricia Cunningham, had responded, "Be careful, Sharon. We can't actually do anything illegal." Sharon's reply, "Who said anything illegal? I'm just planning some improvements to my property." When Robert showed me these emails, I felt a mixture of vindication and anger. She planned this. She deliberately built on my land to harass me. "That's exactly what these emails show," Robert said. "This isn't a simple boundary dispute anymore. This is intentional trespass with malicious intent. We're amending our complaint." The amended complaint added claims for intentional infliction of emotional distress and sought even higher punitive damages. We also filed an emergency motion for a preliminary injunction to prevent Sharon from making any additional improvements or alterations to my property. Sharon fired her cheap attorney and hired a bigger firm, probably realizing she was in serious trouble. Her new lawyers tried every trick in the book. They filed motions to dismiss, motions for summary judgment, and even tried to argue that the HOA bylaws gave Sharon special rights as president. Nothing worked. Judge Martha Rodriguez saw through all of it. The day of the preliminary injunction hearing, I sat in the courtroom watching Sharon squirm under questioning. Her new attorney, a guy named Dennis Craftman who wore too much cologne and smiled too much, tried to paint her as a confused homeowner who'd made an honest mistake. Mrs. Whitmore simply relied on what she believed to be an accurate property assessment, he argued. Judge Rodriguez, a no-nonsense woman in her 60s who'd been on the bench for 20 years, wasn't buying it. "Counsel, I've read the emails. Your client wrote, and I quote, 'If we can't force him out through fines, maybe we can make his property less appealing.' That doesn't sound like confusion to me. That sounds like intent." "Your Honor, that email was taken out of context." "I don't think it was," the judge interrupted. "Mr. Chen, I'm granting your motion for preliminary injunction. Mrs. Whitmore is hereby ordered to stay off Mr. Barrett's property and make no additional alterations, improvements, or changes to the disputed area pending the outcome of this case. If she violates this order, she'll be held in contempt." That was a small victory, but the real battle was still ahead. The trial date was set for 7 months later, in October. In the meantime, that fence remained standing on my property, a daily reminder of Sharon's audacity. Life got complicated during those 7 months. Sharon began a campaign of harassment that went beyond the fence. Suddenly, I was receiving violation notices for things that had never been problems before. My house number was allegedly the wrong font. My garage door needed repainting. My doormat was a non-approved color. Each violation came with a fine of $100 to $300. I forwarded every single notice to Robert, who documented them all as evidence of harassment. We also discovered that no other homeowners in the neighborhood were receiving even a fraction of the violation notices I was getting. Robert subpoenaed the HOA's records and found that in the 6 months since the lawsuit was filed, I'd received 43 violation notices. The next highest number for any other homeowner was 4. "This is retaliation, plain and simple," Robert said. "We're adding it to our case." Amanda was incredible through all of this. She'd come over after work and we'd sit on my front porch, deliberately visible, refusing to let Sharon intimidate us. Other neighbors started to notice what was happening, and several of them reached out to offer support. My neighbor to the other side, Tom Ramirez, a retired firefighter, came over one evening with his wife Maria. "We've been watching what Sharon's doing to you," he said. "It's not right. If you need us to testify or anything, we're there." It turned out Tom and Maria had their own stories about Sharon's abuse of power. 3 years ago, when their grandson had stayed with them for a summer, Sharon had filed noise complaints every single day, claiming the boy was disrupting the neighborhood. He was 8 years old and playing outside during daylight hours. Another neighbor, Jennifer Park, who lived across the street, told me Sharon had tried to fine her for having a vegetable garden in her backyard, because it supposedly violated the aesthetic standards of the community. Jennifer had fought it and won, but only after months of stress and several $100s in legal fees. As more neighbors came forward, I realized Sharon had been terrorizing the entire neighborhood for years. Most people had either given in to her demands or moved away. I was apparently the first person to actually take her to court over something substantial. The HOA board held a meeting in August to discuss the lawsuit. Sharon tried to hold it without notifying me, but Robert had made sure I was aware of my rights. I showed up with Amanda, and we sat in the back of the community center while Sharon addressed the other board members. "This lawsuit is frivolous and wasteful," she said, standing at the front of the room like she was giving a speech to Congress. "Stephen Barrett is trying to bully the HOA and undermine the authority of this board. We need to stand firm and not give in to his demands." One of the other board members, Frank Morrison, a retired accountant, raised his hand. "Sharon, I've looked at the surveys. The fence is on his property." "Why don't we just move it and be done with this?" Sharon's face turned red. "Because that would send a message that we can be pushed around. We have to show strength." "But we're not in the right here," Frank insisted. "This is going to cost the HOA a fortune in legal fees." "We're spending community funds to defend your mistake." "It's not a mistake," Sharon snapped. "And if you're not going to support me, maybe you should resign from the board." Frank looked like he wanted to say more, but he backed down. I could see Sharon's control over the board, the way she intimidated people into compliance. It made me even more determined to win this case. As summer turned to fall, the legal bills piled up. I'd already spent nearly $15,000 on attorney's fees, survey costs, and court filing fees. It was a lot of money, but Robert kept assuring me that we'd recoup it all when we won. More importantly, this wasn't just about money anymore. This was about standing up to a bully and protecting my property rights. The trial finally began on October 15th. It was a bench trial, meaning Judge Rodriguez would decide the outcome rather than a jury. Robert had explained that this was actually better for us because property disputes involve technical legal issues that judges understand better than most jurors. The courtroom was packed. Several neighbors showed up to watch, along with some local reporters who'd gotten wind of the case. Apparently, HOA disputes were hot topics in the Phoenix metro area, with several high-profile cases making headlines in recent years. Sharon arrived with her legal team, looking confident in a navy pantsuit. I was wearing my best suit too, and Amanda sat right behind me in the gallery for moral support. The trial began with opening statements. Robert laid out our case clearly and methodically. Your Honor, this is a simple case of trespass and encroachment. The defendant, Sharon Whitmore, built a fence 10 feet onto my client's property. She knew the property line location, she knew she was encroaching, and she did it anyway as part of a harassment campaign against Mr. Barrett. The evidence will show that Mrs. Whitmore, abusing her authority as HOA president, has been trying to drive Mr. Barrett out of the neighborhood because she views him as a problem resident. When other methods failed, she quite literally took his land. Dennis Craftman, Sharon's attorney, tried a different approach. Your Honor, this is a case of an unfortunate miscalculation. Mrs. Whitmore believed in good faith that she was building on her own property. Any correspondence that the plaintiff has taken out of context was simply Mrs. Whitmore doing her job as HOA president to maintain community standards. We ask the court to find that, while the fence may technically be over the property line, this was done without malicious intent, and the appropriate remedy is simply to move the fence with no additional damages. The first witness was the professional surveyor Robert had hired. He brought large poster board displays showing the property lines, the fence location, and the extent of the encroachment. He testified that the fence was clearly and unambiguously on my property, and that any competent survey would have shown this. Under cross-examination, Craftman tried to suggest that property lines in older neighborhoods can be confusing. The surveyor shut that down quickly. These properties were surveyed in 1987 when the development was built. The markers are still in place. There's no ambiguity here. Next, I testified. Robert walked me through everything, from moving into the neighborhood to the constant violation notices to discovering the fence. I kept my cool and stuck to the facts, even when Craftman tried to rattle me during cross-examination. Isn't it true, Mr. Barrett, that you've been a difficult resident? That you've repeatedly violated HOA rules? He asked. I've received many violation notices, yes, I said. But most of them were either incorrect or for incredibly minor things that no reasonable person would consider violations. I believe the notices were part of a harassment campaign. That's a serious accusation. What proof do you have? The sheer number of notices I received compared to other residents. 43 in 6 months, compared to an average of less than 1 per month for everyone else in the neighborhood. That's not enforcement of rules. That's targeting. The afternoon of the first day, Robert called Frank Morrison, the board member who'd questioned Sharon. Frank testified about how Sharon had dominated the HOA board and made unilateral decisions without proper votes or discussions. She ran the HOA like her personal fiefdom, Frank said. If you disagreed with her, she'd make your life difficult. I stayed on the board hoping to moderate her behavior, but I wasn't very successful. Can you tell the court about the fence decision? Robert asked. There was no board discussion about building a fence. Sharon just did it. When I asked her about it after the fact, she said it was her property and none of the board's business. But later, when the lawsuit was filed, she suddenly wanted the HOA to pay for her legal defense, claiming she'd been acting in her official capacity. Did the board agree to pay her legal fees? We took a vote. It was 3-2 in favor, but only because Sharon pressured the other members. She threatened to resign and claimed the HOA would collapse without her leadership. The next day of trial, Robert introduced the email evidence. Judge Rodriguez spent nearly an hour reading through the printed emails, her expression growing more severe with each page. When she looked up at Sharon, I could see the disapproval in her eyes. Mrs. Whitmore, these emails suggest you had a specific intent to harm Mr. Barrett. Do you want to explain them? The judge asked. Sharon stood up, looking flustered. Your Honor, I was frustrated. Mr. Barrett wasn't following the rules and I was trying to maintain community standards. Sometimes I said things in private that I didn't really mean. You wrote that you wanted to make his property less appealing to force him out. Then, shortly after, you built a fence on his property. That seems like more than just venting frustration. I didn't know the fence was on his property at the time, Sharon insisted. But you didn't hire a professional surveyor. You used a handheld GPS device. Why not hire a professional if you wanted to be sure? Sharon didn't have a good answer for that. She stammered something about cost savings, but it fell flat. Everyone in the courtroom could see she was lying. Robert then called several neighbors to testify about Sharon's pattern of harassment and abuse of authority. Tom and Maria Ramirez talked about the daily noise complaints about their grandson. Jennifer Park described the vegetable garden incident. A man named David Ortiz, who'd lived in the neighborhood for 15 years, testified that 4 families had moved away in the past 3 years specifically because of conflicts with Sharon. She makes living here miserable if you don't follow her exact vision of how things should be, David said. People just get tired of fighting and leave. By the 3rd day of trial, Sharon's defense was crumbling. Craftman tried to call character witnesses to testify about Sharon's dedication to the community, but their testimonies came across as scripted and unconvincing. One woman, Barbara Fields, actually helped our case when she admitted under cross-examination that she was afraid to contradict Sharon because Sharon had threatened to fine her for having the wrong style of porch light. The closing arguments took place on the afternoon of the 3rd day. Robert was powerful and persuasive. Your Honor, this case represents everything that's wrong with HOA overreach and abuse of authority. Sharon Whitmore used her position to target a homeowner she didn't like, and when other methods of harassment didn't work, she quite literally stole his land by building a fence 10 feet onto his property. She knew what she was doing. The emails prove it. The timing proves it. Her refusal to hire a professional surveyor proves it. Mr. Barrett is entitled to the removal of the fence, compensation for his damages, reimbursement of his legal fees, and punitive damages to send a message that this kind of behavior will not be tolerated. Craftman's closing argument was desperate. He tried to minimize the emails, downplay the encroachment, and paint Sharon as a dedicated volunteer who'd made an innocent mistake. It was unconvincing, and I could tell Judge Rodriguez wasn't buying any of it. This court will take the matter under advisement, Judge Rodriguez said. I'll issue a written decision within 30 days. Those 30 days were agonizing. I tried to focus on work, but I kept checking my email constantly, waiting for word from Robert. Amanda kept me sane, reminding me that we'd presented a strong case and that the evidence was on our side. 27 days after the trial ended, Robert called me. We won. Complete victory. I actually had to sit down. What did she order? Everything we asked for and more. The fence has to be removed within 30 days at Sharon's expense. She has to pay you $12,000 for property damages and loss of use. She has to pay your attorney's fees, which are currently at $18,000. And here's the big one. Judge Rodriguez awarded $50,000 in punitive damages, citing Sharon's malicious intent and abuse of her position as HOA president. $50,000. I could barely process it. The judge was really angry. She wrote a 15-page decision, absolutely eviscerating Sharon's actions. She called it a flagrant abuse of authority designed to deprive the plaintiff of his property rights through intimidation and illegal encroachment. She also ordered Sharon to resign from the HOA board immediately. I felt a wave of relief wash over me. So it's really over. Well, Sharon has 30 days to appeal, but honestly, with a decision this strong, I don't think any appellate court would overturn it. You won, Stephen. I called Amanda immediately, and she screamed with joy so loudly I had to hold the phone away from my ear. That evening, Tom and Maria came over, and we celebrated on my front porch with beer and pizza. Other neighbors stopped by when they heard the news, and it turned into an impromptu block party. Sharon stayed in her house with the lights off. I almost felt bad for her. Almost. The written decision arrived a week later, and I read every word of Judge Rodriguez's opinion. It was even better than Robert had described. The judge had systematically destroyed every argument Sharon's attorneys had made. She'd found that Sharon had committed intentional trespass, that the emails proved malicious intent, and that her pattern of harassment constituted intentional infliction of emotional distress. One paragraph particularly stood out. Mrs. Whitmore's conduct represents a cautionary tale about the dangers of unchecked HOA authority. While homeowners associations serve a legitimate purpose in maintaining community standards, they are not above the law. When an HOA president uses their position to target individual homeowners through harassment, intimidation, and illegal encroachment on their property, the courts must respond with clear and decisive remedies. The punitive damages awarded in this case are intended to send a message that such behavior will not be tolerated in our civil society. Sharon did not appeal. Instead, she put her house on the market 2 weeks after the decision was issued. The fence came down on day 29 of the 30-day deadline, removed by the same construction crew that had built it. They looked embarrassed as they worked, and one of them apologized to me. "We should have checked the property line ourselves," he said. "Lady gave us GPS coordinates and insisted that's where it went. We just figured she knew what she was doing." "Not your fault," I told him. "You were just doing your job." Sharon also had to pay the judgment. Her attorney tried to negotiate a payment plan, but Robert insisted on full payment within 60 days, or we'd start garnishing her wages and placing liens on her property. She paid in full on day 58, probably from the proceeds of selling her house. The HOA held an emergency election for a new president. Frank Morrison was elected unanimously. His first act was to review and rescind dozens of bogus violation notices, including most of mine. His second act was to implement new rules requiring board approval for any violation notice exceeding $100 in fines. "We're going back to basics," Frank announced at a community meeting I actually bothered to attend. "This is supposed to be a nice place to live, not a police state. We're going to focus on real issues like maintaining common areas and organizing community events, not hassling people about mailbox positioning." The neighborhood felt different after that. People were friendlier, less stressed. Several residents who'd been considering moving decided to stay. One couple, Henry and Lisa Brennan, actually thanked me for standing up to Sharon. "We've been miserable for 2 years," Lisa said. "You fighting back gave us hope that things could change, and now they have." The local news picked up the story after the judgment became public record. A reporter from the Arizona Republic called and asked to interview me. The resulting article, titled "Homeowner Wins Big in HOA Boundary Dispute," ran on the front page of the local section. It detailed Sharon's abuse of authority and the court's strong rebuke of her actions. That article generated a lot of attention. I received calls and emails from other people dealing with HOA nightmares, asking for advice. I referred them all to Robert, who told me later that he'd picked up 6 new HOA dispute cases as a result of the publicity. Sharon moved out on a cold day in January, about 3 months after the judgment. I happened to be checking my mail when the moving truck arrived. She saw me, and for a moment our eyes met. I expected her to look angry or defiant, but instead she just looked defeated and old. She quickly looked away and went back into her house. I didn't feel triumphant watching her leave. I felt relieved. This whole ordeal had consumed nearly a year of my life and cost me thousands of dollars in legal fees, even with the reimbursement. But I'd stood up for my rights and I'd won. More importantly, the neighborhood was a better place because of it. Amanda and I got engaged that spring. We'd grown closer through the whole fence dispute, and she'd been my rock when things got tough. We planned a small wedding for the following summer, right there in Scottsdale. Tom and Maria offered to host the reception in their backyard, which was generous given that Maria loved to garden and had transformed their yard into something beautiful. The spot where Sharon's fence had stood on my property was now a flower garden that Amanda had designed. She'd planted desert roses, Mexican bird of paradise, and various succulents that thrived in the Arizona heat. It was beautiful and served as a reminder that something good can grow even from conflict. Frank turned out to be an excellent HOA president. He was reasonable, fair, and actually listened to residents' concerns. The quarterly meetings became pleasant affairs where people discussed real community issues rather than complaining about trivial violations. The neighborhood thrived under his leadership. I ran into Dennis Craftman, Sharon's former attorney, at a local restaurant about 6 months after the case ended. He was with his wife, and he actually came over to my table where I was dining with Amanda. "Mr. Barrett, I just wanted to say that you were right and we were wrong," he said, extending his hand. "I should have advised Sharon to settle that case early on, but she insisted on fighting it. I've learned a lot from that experience about picking my clients more carefully." I shook his hand, appreciating the honesty. "No hard feelings, you were doing your job. Still, I could have done it better. Congratulations on your engagement, by the way. I saw the announcement in the paper." After he left, Amanda raised her eyebrows at me. That was unexpected. "People can surprise you," I said. "Sometimes for the better." The money from the judgment helped offset the stress and expense of the whole ordeal. After paying Robert's fees and recouping my costs, I still walked away with about $40,000. Amanda and I used some of it for the wedding and put the rest toward a down payment on a rental property we bought together as an investment. Life was moving forward in positive ways. I never heard from Sharon again after she moved. According to neighborhood gossip, she'd bought a condo in Tempe and was living a much quieter life. Someone said they'd seen her working part-time at a garden center. I hoped she'd learned something from the experience, but I honestly didn't spend much time thinking about her. The real legacy of the fence dispute was the change it brought to Meadowbrook Hills. Other HOA boards in the area took notice of the judgment and the substantial damages awarded. Several HOAs revised their policies and procedures to include more oversight and checks on presidential authority. Arizona legislators even introduced a bill to reform HOA regulations, though I didn't follow it closely enough to know if it passed. For me, the experience taught me several important lessons. First, you have to stand up for your rights, even when it's difficult and expensive. If I just accepted Sharon's fence, she would have gotten away with stealing my land, and her behavior would have continued unchecked. Second, documentation is everything. The emails, photos, surveys, and violation notices we'd carefully preserved became the foundation of our case. Third, having good people in your corner matters. Robert, Amanda, and my supportive neighbors made all the difference. Looking back, I'm grateful for how everything turned out, even though I wouldn't want to go through it again. My property was restored. Sharon's reign of terror ended, and the neighborhood became a genuinely pleasant place to live. The legal victory felt good, but the real win was creating positive change for everyone. Amanda and I got married on a perfect June evening. The ceremony was in a small chapel in Old Town Scottsdale, followed by a reception in Tom and Maria's garden. Neighbors filled the yard, along with friends and family who traveled from all over. Even Frank gave a toast, joking that he was glad I'd decided to stay in the neighborhood despite all the drama. To Stephen and Amanda, he said, raising his glass, "May your marriage be long, happy, and completely free of property disputes." Everyone laughed and cheered. As I looked around at the smiling faces, at the community that had rallied around me, I felt incredibly fortunate. This was what a neighborhood should be: people looking out for each other, supporting each other, and standing up for what's right. We honeymooned in San Diego, spending a week on the beach and deliberately not thinking about HOAs, fences, or property lines. When we returned to Scottsdale, our house felt like a true home for the first time since I'd moved in. The stress and anxiety that had hung over the property during the dispute were gone, replaced by a sense of peace and belonging. Amanda officially moved in after the honeymoon, bringing her furniture and transforming the house with her designer's eye. She repainted several rooms, rearranged everything, and turned my bachelor pad into a real home. The backyard became her particular project, and she spent hours planning gardens and outdoor living spaces. "No fences, though," she joked one evening as we sat on the patio looking at her sketches. "I've had enough of fences to last a lifetime." "Agreed," I said, pulling her close. "Maybe just a nice low wall someday, clearly on our property with documentation from 3 independent surveyors." She laughed, and the sound filled the warm desert evening. Life was good. The fence was gone, Sharon was gone, and my future with Amanda stretched out before me full of possibility. The HOA eventually used some of its reserve funds to install new landscaping in the common areas, making the neighborhood even more attractive. Property values increased, which meant everyone benefited from the improved environment. Several new families moved in, and the community became more diverse and vibrant. The atmosphere shifted from fearful and restrictive to welcoming and neighborly. I kept in touch with Robert Chen, who became something of a friend beyond just being my attorney. He invited Amanda and me to his firm's holiday party, where I met other people who'd been involved in property disputes. Hearing their stories reminded me how common these issues were, and how important it was that I'd fought back against Sharon's overreach. One woman at the party, Margaret Torres, told me her HOA had tried to force her to remove solar panels from her roof, claiming they violated aesthetic standards. She'd fought them with Robert's help and won, citing Arizona's Solar Rights Act. Her case had actually been cited in some of the legislative discussions about HOA reform. "We're all part of a bigger movement," Robert said that evening. "Individual homeowners standing up against HOA abuse. Every case we win makes it harder for bad HOAs to get away with overreach." That perspective made me feel like the year of stress and legal battles had served a larger purpose. I wasn't just defending my own property. I was contributing to a broader effort to protect homeowners' rights across Arizona and potentially beyond. As time passed, the fence dispute became just another story in our lives, something we'd tell at dinner parties or when new neighbors asked how Amanda and I had met. The emotional intensity faded, leaving behind valuable lessons and the satisfaction of having done the right thing. Tom Ramirez retired from his part-time work and spent more time working on neighborhood projects. He and I built a little free library box at the corner of our street, filling it with books for neighbors to share. Maria started a community garden club, and several residents transformed their yards into desert-appropriate landscapes that were beautiful and water-efficient. Frank served 2 terms as HOA president before stepping down, satisfied that he'd restored sanity to the organization. His successor, a woman named Christine Park, Jennifer's sister-in-law, continued his reasonable approach to community management. The HOA became what it should have been all along, a low-key organization focused on maintaining common areas and organizing the occasional block party. Years later, I sometimes drive past Sharon's old house. A nice family lives there now, with 2 kids and a friendly dog. They've repainted the exterior and added some cheerful landscaping. The property looks happy in a way it never did when Sharon lived there. I hope she found peace wherever she ended up, but I'm mostly just glad the neighborhood moved on without her. The final payment from Sharon came through exactly as ordered. Robert handled all the financial details, making sure every dollar was accounted for. With the punitive damages and the reimbursed legal fees, I actually came out ahead financially, though that was never really the point. The point was justice, property rights, and refusing to be bullied. Amanda and I talked about having kids and agreed we wanted to raise them in Scottsdale, in this neighborhood that had become truly ours. The thought of our future children playing in the yard that I'd fought to protect gave me a deep sense of satisfaction. This was our land, our home, our community. I framed Judge Rodriguez's decision and hung it in my home office, not as a trophy but as a reminder. A reminder that standing up for what's right matters, that the legal system can work when you have a good attorney and solid evidence, and that communities thrive when people refuse to accept abuse of authority. The last time I thought about the fence dispute in any meaningful way was when a journalist writing a book about HOA conflicts reached out to interview me. I spent an hour on the phone with her, recounting the whole story. She told me it would be a featured chapter in her book about property rights and community governance. Your case is important because it shows how individuals can fight back against institutional overreach, she said. And when? After that conversation, I realized the fence dispute would outlive my personal memory of it. It would exist in legal databases, news archives, and now a book, serving as precedent and inspiration for others facing similar situations. That legacy felt meaningful in a way I hadn't fully appreciated before. Amanda and I are still living in that house in Meadowbrook Hills. We've made countless improvements and memories there. The backyard garden blooms year-round now, a testament to Amanda's skill and vision. We've hosted dozens of gatherings with friends and neighbors, building the kind of community life that Sharon's authoritarian approach had nearly destroyed. Sometimes, when I'm sitting in the backyard with a cold drink, watching the sunset paint the Arizona sky in shades of orange and pink, I think about how close I came to just accepting that fence. How easy it would have been to let Sharon win, to avoid the conflict and expense of a lawsuit. But I didn't, and that decision changed everything. The 10 feet of yard that Sharon tried to steal is now part of an extended patio that Amanda designed. We put in a fire pit and comfortable seating, and it's become the heart of our outdoor living space. Friends gather there on cool desert evenings, and I always feel a small sense of victory knowing that Sharon tried to take this space from me and failed. Justice, I learned, isn't just about court decisions and financial awards. It's about restoring what's right, about protecting your home and your peace of mind, about refusing to let bullies win. The fence is gone, Sharon is gone, but the lessons remain. Stand up for yourself, document everything, find good allies, and never give up on what's right. My life moved forward in ways I couldn't have imagined during those stressful months of litigation. The experience made me stronger, more confident, and more willing to fight for what matters. It brought Amanda and me closer together, proved that communities can change for the better, and showed that individual action can make a real difference. The story could have ended differently. If I'd had a less competent attorney, a less sympathetic judge, or weaker evidence, Sharon might have won. But I got lucky in addition to being right, and that combination proved unstoppable. The house that had felt like a battleground became a true home. The neighborhood that had been oppressive became welcoming, and the future that had looked uncertain became bright with possibility. As I write this, several years after the fence finally came down, I can honestly say it was worth every dollar, every hour of stress, every moment of uncertainty. Not just because I won, but because winning mattered. It mattered for me, for my neighbors, for my marriage, and hopefully for other homeowners facing similar battles across the country. The fence is gone, but its absence remains the most satisfying kind of emptiness. In its place stands something better: a restored property line, a beautiful garden, a peaceful community, and the knowledge that when push came to shove, I pushed back and won. That's not a story about a fence. That's a story about justice, determination, and the fundamental right to enjoy your own property without interference from those who think power means they can take whatever they want. Sharon learned an expensive lesson about respecting boundaries, both physical and ethical. The neighborhood learned that change is possible when someone is willing to stand up and fight. And I learned that home isn't just about the building you live in or the land you own. It's about knowing you belong somewhere, that you've earned your place, and that you'll defend it when necessary. The fence dispute taught me all of that and more. And for those lessons, as painful as they were to learn, I'm ultimately grateful.